Good morning, everybody. We're going to give folks just a few moments here to gather and join us, and then we will kick off today's webinar. I know we do have a full house and a very, very busy agenda for you all today. So we appreciate you joining us, whether you are on our Zoom webinar and joining us live this morning, or whether you're catching up with us on YouTube, which I think some of you may be. I'm seeing our participants hitting the 300 numbers here pretty quickly. All right. I will go ahead and get us started. So again, thank you all so much for joining us today. My name is Tracy Marshall. I serve as the Division Director for the Family and Medical Leave Insurance Division here at the Colorado Department of Labor and Employment. I'm joined this morning by David Gallivan, who leads our Policy and Appeals branch, and also several members of his team. Today, we are going to focus on our upcoming benefits portal and give everyone a preview of the process for that parental and bonding leave. We will open our time up for questions at the end, and we'll answer as many questions as we can in the next hour. But if we don't get to you, please don't take it personally. You're certainly welcome to email or call us, and we really are committed to making sure that everyone in Colorado has the information that they need to make family work for them. Some quick housekeeping items here. This presentation will be available on family.colorado.gov shortly following the webinar. We'll also share it with everyone who is registered, no matter the format in which they registered. We will ask that you put your questions in the Q&A function of the Zoom meeting, as the chat has been disabled. Our team of panelists will be sharing helpful links through the chat as we move throughout the session. You're certainly welcome to copy and save those. You can also find recordings of any previous webinars we've done on our YouTube channel, and they cover a variety of different topics. A quick glance here, the agenda has been up on your screen, but we're going to talk about what FAMLI is, our progress on the implementation of the FAMLI program, what events will make you eligible for FAMLI, and then we'll be taking that deep dive into all things related to parental bonding and pregnancy leave today, and then we'll end with your questions. Next slide. So I'm going to start here by giving a quick overview of the program itself. As you may be aware, FAMLI will be providing paid leave for Colorado workers to take care of themselves or their loved ones during certain life events, which we'll get into more in a moment. The program will cover almost all workers in Colorado, including those who are self-employed if they wish to participate. The FAMLI program is a social insurance program. That means that both employers and employees contribute to the fund that will eventually be paying out the benefits. The premiums are set currently to 0.9% of the employee's wage, with half of that being paid by the employer and the other half by the employee. The initial FAMLI premium rate is fixed at that 0.9% rate through the end of 2024. From 2025 and beyond, the director of the FAMLI division can set the premium rate according to a formula based on the value of the fund every year. FAMLI premiums are capped at 1.2%, and that's by law. What we've seen in several states is that premiums have been able to decrease and benefits have been able to increase over time. Next slide. So here's a high-level overview of our timeline and how we've been getting ready for the launch of FAMLI benefits coming up in just a few months' time. We're approaching some major deadlines, so I do want to highlight where we're at with those. As you know, we began building out our benefits system earlier this year, and late last summer, we launched the healthcare provider portal, which is part of our benefits system. For employers on the webinar, reminder that tomorrow, Halloween, is the deadline for those 3 wage reports and premiums. And it's also the deadline for employers to apply to get approval to use a private insurance plan, which would cover the same or greater benefits as the family plan. Approved employers will get a refund for any premiums paid earlier in the year. We have lots of how-to videos and instructions on our websites on all of those previous monthly webinars, just in case you need any help with that. Before the end of the year, we are planning to launch the benefit system, allowing Colorado workers to apply for their anticipated leave before we finally begin issuing payments in January of next year. And we will be giving you a preview of that benefits portal here today. A quick refresher on the life events that will make Colorado workers eligible for benefits starting again in January. So FAMLI will provide up to 12 weeks of paid leave for Colorado workers to take care of themselves and their loved ones. Those who experience pregnancy or childbirth complications may be eligible for an additional 4 weeks, making that total 16 weeks. And we will talk more about that as we move through the presentation. Covered workers will be able to apply for paid family leave benefits during certain life events, which include a serious health condition, the management of that, making arrangements ahead of a military deployment, or to deal with the immediate needs and impacts arising from intimate partner violence or sexual assault. The program, as we said, will cover almost all workers in Colorado, including gig workers and those who are self-employed if they wish to participate. I'm going to hand you over to David to dive into things a little bit more deeply for us.
All right, thank you. And let's start with a little bit deeper dive into that concept of a serious health condition. So what does that mean? We've got the definition here on this slide. It's an illness, injury, impairment, pregnancy, recovery from childbirth, or a physical or mental condition that involves inpatient care in a hospital, hospice, or residential care facility, or continuing treatment by a healthcare provider. So it's pretty broad. If you are receiving medical treatment really for some variety of a medical issue, it could be considered a serious health condition. What we're going to be looking at there is the certification of a healthcare provider. And so what is that? It's any person licensed, certified, or registered under federal or Colorado law to provide medical or emergency services. Now that can include physicians, doctors, nurses, emergency room personnel, midwives, but it's not limited to that. If somebody is certified under some variety of a healthcare provider rule by the Department of Regulatory Agencies, they could fall within our guidance there for a healthcare provider. But let's go ahead and move on to the main topic of today's webinar. On the next slide here, we're going to talk a little bit about how to prepare for bonding leave. We want to talk about the parental bonding leave. And this, just to be clear, when we say bonding leave, we mean for a parent to bond with a new child, not for you to bail your friends out of jail. That's an entirely different kind of bond, and that's something we have nothing to do with. So this is the number one reason why people use paid family and medical leave in other states, and we expect it's going to be the same here. It's to spend time with that new child, that form of parental leave for a birth, an adoption, or foster placement. So let's start with childbirth. We call that a foreseeable event. Hopefully, if you're giving birth to a child, it's not coming as a surprise to you. So you can apply for this type of leave up to 30 days before your first anticipated absence from work. Employers are entitled to 30 days notice of when you plan to start your leave. We'll talk a little bit more about that in a moment. If this is you, you'll need to provide proof of birth, which can be a birth certificate or some documentation from a healthcare provider that verifies the birth. I should add here, we're going to work a little bit differently than the FMLA. So if you have some experience with the federal process, we're going to do things our own way here in Colorado. So when it comes to a new child, you can't apply for a birth certificate or prove that a child was born until after that child is born. So although you can certainly begin your application for bonding leave, the paperwork in reality can't be completed after the birth. Birthing parents could, however, file a serious health condition claim in advance of their birth and have their doctor complete the forms for that for your pregnancy. and then you'd be using some of your leave during the pregnancy for that serious health condition, and some of it after for that bonding. Typically, your doctor will recommend 6 to 8 weeks to recover from birth pregnancy. So you could potentially file this claim before your baby's born, and then you're going to be having that 6 to 8 weeks of a serious health condition leave, and the remaining would be used for bonding. So just to take a step back, you have a pool or a bucket, a total of 12 weeks per year to use for leave. And so there's different reasons why you can use that leave, but they all come out of that same allotment of 12 weeks. So what we're talking about here is really the label that we put on that leave. It doesn't give you any more or any less leave. So you can use that serious health condition leave. You can apply and start that even before the birth. And then once you've reached the point where your doctor says you no longer need that, you can take your remaining leave for bonding. I do want to mention one thing that makes this such an absolute game changer for new parents. And that's self-employed parents and gig workers will be eligible. And I've already seen some questions come through in the chat. We're going to be probably answering some of those questions a little bit later. But here's the thing. If you are self-employed, you drive for Uber, you DoorDash, you're a plumber, you're a contractor, you're still eligible for this. So anyone who works on their own right now knows that you don't have any other kind of type of safety net out there. There's no service that's going to be providing you with a wage replacement if you take that time off. But family will. And we've got lots of resources on our website that explain how you will do this if you are self-employed. And we're going to be dropping some of those in the chat. So what about babies born in 2023? So you're eligible for bonding leave in the first year after a birth, adoption, or foster care placement. So you may have had a baby in 2023, and that child is still going to have some of that first year in 2024. So benefits aren't available until January 1st, 2024, but they will be available to you. Future family benefits also aren't dependent on any earlier benefits already taken before that January 1st, 2024 date. So if you took time off in 2023, paid or unpaid, to care for a new child, it doesn't affect your eligibility for family benefits in 2024. So if you've used federal FMLA benefits and employer-provided parental leave, you are still eligible for family benefits for as much time that falls in 2024 that is part of that first year of that new addition to your family. So a parent could take work-sponsored unpaid bonding leave in 2023 and then take it again in 2024. So let's break that down. Think about a Colorado worker who welcomed a new child in July of 2023. They might have been eligible for 12 weeks of unpaid federal family leave during 2023, depending on the size of the employer. They also might have had paid or unpaid parental leave from their employer. In January of 2024, Colorado family benefits begin. That same parent is going to be eligible for another 12 weeks of paid time off because it's been less than 12 full months since the child's arrival. Parents won't be penalized or lose out on family-funded leave just because they took bonding leave in 2023. This is kind of a one-time deal. This is because family leave isn't available this year. In the future, a lot of those leaves are going to run concurrently, but now, because you weren't eligible, you will have up to 12 weeks, assuming that you have that 12 weeks until your child's first birthday or until the 1-year anniversary of the adoption of the foster placement. Here's a biggie. I love this. It's not just birthing parents. When family benefits begin in 2024, leave for parental bonding with a new child is not limited to the parent who gives birth. We get this question all the time in our Facebook Lives and our webinars is, what about fathers? Yeah, fathers are covered under this. It's parental leave. So new parents are eligible for that paid leave in the first 12 months after a birth, adoption, or foster care placement. Both parents are eligible for family covered bonding leave. You don't have to take the weeks concurrently. So we do expect that there are going to be some parents out there who, mom might take the first 12 weeks, dad might take the second 12 weeks, and then, you've got 24 weeks with that child, but each parent takes their own. When it comes to foster parents and adoptive parents, they're eligible for 12 weeks of bonding leave as well, regardless of how old the child is. Doesn't always need to be before the child's first birthday, as long as it's within the first year from the adoption, or the foster placement. Uh, this also applies to anyone designated in loco parentis. I really try to avoid using Latin, but this is what the law says. It's just a fancy Latin way of saying that it's somebody who is standing in the footsteps or in the shoes or the place of a parent. I like to call this, and this is really going to be a generational thing, the Uncle Phil doctrine, right? So you're on a playground, you get in one little fight, your mom gets scared, sends you to live with your aunt and uncle in Bel Air. You're going to have somebody out there who may not be a parent biologically, but who is standing in that role of really a guardianship. They're going to be eligible for that leave as well. There's one thing to note here, though, if we're talking about foster placements, if there's a foster placement that's followed by an adoption, you get that 12 weeks per child. So if you take 12 weeks of bonding leave with that child at the foster placement and then subsequently adopt, that child's been in your house, they've been a part of your family, you have presumably, hopefully bonded, so you're not going to be eligible for another 12 weeks at the adoption. Let's go ahead and take a look at some eligible workers and how they can take that time off. So there's lots of different ways to use the leave. You don't have to take it all at once. You can split it up. So the maximum amount of time that you get is 12 weeks within a 12-month period. The one exception to this is for individuals giving birth who have childbirth or pregnancy complications may be eligible for an additional 4 weeks. But how do you use this leave? You can take it as a single block of time. You can take it on an intermittent basis or as a reduced schedule. Each situation will be unique. Continuous leave is the most straightforward. You leave work one day, you come back 12 weeks later. That's a continuous leave. That's what a lot of people do here, is just take that as one block. Intermittent leave is a separate block of time that occurs at irregular intervals that are not continuous or steady within a 6-month period. So this may be something that gets used sometimes if you need medical treatment. So you're taking this time off if you need to go to medical appointments or if you're having a flare-up of something. But new parents are eligible to do that as well, to maybe alternate weeks with a partner or to take some time off, go back, do some work, take some more time off. The third option is a reduced work schedule. This is somebody who's going to be basically working part-time and using family to cover up their other time. This is, again, available for bonding leave for parents, but it is something that we frequently see with people who need medical treatment, that they might be taking some time off or reducing their schedule, or if they've got some restrictions that limit their availability for the number of hours. But let's talk about a parental bonding leave claim as an example here. So you welcome a new baby. You'd like to take 4 weeks to bond with the baby right after birth. Then you return to work for several weeks. Then you want to go back on leave to bond with the baby for the remaining 8 weeks before the child's first birthday. That's acceptable. You've got 2 separate continuous leave claims. When you go to open your second or third block of continuous leave to bond with your child after returning to work, you'll be able to link it to the first claim, which will result in faster processing times. I've seen a little bit of the computer system that is being designed to process these claims. I'm not making it sound as easy as it's going to be. You follow the steps through, and we're going to have a great customer care team there as well that can walk you through it. But the important thing for you to know today is that eligible workers can choose how and when to use their time. And we're going to have a lot more information about these leave types on our website. So what about relatives? Can relatives apply for family leave? I'm a lawyer. My answer to every question is maybe it depends. We distilled that down to yes and no for the slide here. A little bit more about some caregivers who are not parents. Only parents are eligible for bonding leave. But that does include anyone who is in loco parentis of the child. And we talked about that earlier. So if your grandparent or another relative, but you haven't formally assumed responsibility for that child, you're not going to be eligible for bonding leave. However, if you're related to that child and there's a serious health condition involved, say it's a special needs child or a parent who's recovering from those childbirth or pregnancy complications, you may be eligible to use family leave to care for that relative who has a serious health condition. So you're not going to get bonding leave, but you may be able to utilize leave for care for a family member there. In that case, you'll need a healthcare provider to fill out the serious health condition form for the family member, and you get all of those instructions in our portal when it opens later this year. Before we move on and talk about that, let's talk a little bit on our next slide about what is a childbirth complication. A little bit of time here on how somebody might get 16 weeks of leave instead of 12. The law acknowledges that sometimes birthing parents are themselves recovering from a complicated childbirth, while also needing time to bond with a new child. Birthing parents don't have to choose if they need bonding leave or medical leave to care for themselves. They can apply for both. So again, we get 12 weeks for bonding leave, but if as a result of that pregnancy or childbirth, there's also a serious health condition, the law will allow you that extra 4 weeks. So as we mentioned, parents get 12 weeks of bonding leave simply by providing proof that the child arrived within the last 12 months. That doesn't require a healthcare provider's verification. That can be done again with a birth certificate, hospital discharge paperwork, really any official documentation that shows us that, yes, this child does exist and has joined your family. Where healthcare provider is going to come in is where the birthing parent needs that additional medical leave. And that is a situation in which they will need a certification from a healthcare provider. And that's really the only way to get to that point of getting that additional 4 weeks of leave. So with those details and that deep dive, I'm going to hand it back over to Tracy to talk a little bit about the portal.
Thank you so much, David. So now that we've talked a little bit about family eligibility, let's talk about getting those family benefits. Later on this year, we will be opening the My Family Plus system, which is where you'll go to file a claim for parental or bonding leave, or any of the other eligible reasons to file a family claim. We're dropping some screenshots here and some explanations throughout today's webinar. This is a preview of some of the screens that you'll see once the My Family Plus portal launches. You'll start by entering some information about yourself. You'll get an overview of the types of leave that you may be looking for. Again, today we're focused on that parental bonding leave. From there, the portal will let you know all the paperwork you'll need to attach and things like your typical work schedule. All of these details will help to make sure that everyone is verified to get the benefits that they deserve and that the state doesn't underpay or overpay when we start sending out money for these claims. Next slide, here's a look at that parental bonding leave page. As you can see on the slide, we're going to ask you about the child that you're bonding with, and depending on what choice you select, we'll then let you know what documents you'll need to download so that your application can be considered complete. On this example screen, you'll see that we chose the birth of a child. Now I'm going to show you that serious health condition form that you might need in the case of a childbirth complication. If your healthcare provider does not register in the system, you will need to manually enter their information in our system and will then be prompted to download a PDF of a serious health condition form that looks similar to what you can see on the screen. This is the form that you as the patient will then carry to your provider's office to have them complete. Then you'll need to enter that information and upload the signed form as part of your application for the leave. This is obviously just an example. Each form will be unique and will have a barcode that connects it directly to your specific claim. There is no one form fits all in our program. So just to be clear, that serious health condition form is only required if the patient is filing a family leave claim due to their own serious health condition or to care for a family member's serious health condition. For bonding leave claims, parents and guardians only need to show proof that the child they're bonding with is less than a year old and has been in their care for yet less than a year. We do hope that all new parents encourage their healthcare providers to go ahead and register in the My Family Plus system so that any new parents won't get bogged down needing to find their paperwork and they can get things completed quite easily and through a virtual process when they're recovering from any childbirth complications. Finally, I do want to tell you about that tool that we've built specifically for our healthcare providers. The My Family Plus is the online application system that Colorado workers will be using to apply for benefits, but it's also the system that allows healthcare providers to support their patients by certifying that patient's claim for family benefits based on their health condition or the recommended prescribed treatment plan. This portal is already live. We do have hundreds of physicians that have registered directly in the system, which will give them the opportunity to provide that elevated patient experience by supporting their patients and their families when a serious health condition is preventing people from working, and it will help providers get rid of that excess physical paperwork. Providers can register, verify their license to practice. They can add staff member delegates to access their accounts and help them support managing their patients' claims. Then once we open up our system for all Colorado workers, providers will be able to medically certify claims in that same system. So our final slide here before we get into our questions. We do want to hear from you. You can engage with us in a variety of ways. We are on all of the different social media channels, and we also have an amazing contact center with many, many agents that are ready to support you. We're open Monday through Friday, 8 until 4, and you can see that number up on your screen, the 1-866-CO FAMLI, FAMLI. So with that, I will hand us over to our communications team, who will be acting as our moderators for today's Q&A.
Hi, this is Kristen. I will be moderating today's questions. We're going to go through the Q&As and also try to take some from our YouTube audience if we have a chance. Let me just pull up the correct screen so I know I have this where it needs to be. Okay, first question here is going to be for David. David Keenan asks, can my employer turn down my application for family?
No, the employer doesn't have any ability to approve or deny family. What will happen? You'll file a claim. We will review it, and we can deny a claim if it doesn't appear to be appropriate, if you haven't met the requirements under the law. But if you meet all those requirements, we approve the claim, and at that point, you will be eligible for benefits. If you have worked for that employer for at least 180 days, you will also be entitled to job protection under the law. So you'll have to be returned to your position.
All right, good stuff. Okay, next question is probably a common one too. This is from Miranda, and I'm going to follow up to you, David. Miranda wants to know, she says, I have been on unpaid childcare leave since August. So how can my benefits and pay be calculated if I don't have a current pay stub or hours worked to enter? What would she do?
All right. So we calculate benefits based on the same system that unemployment insurance does. And I hope you've not had to experience that calculation. So let me lay it out here. What we do is we look at what we call a base period, which are your last 5 completed work quarters, not including the current one. And there's some room there. There are some alternatives where we might move a quarter or two. But what we do is we look at that period of time, that's your base period. We find the period, the quarter in which you were paid the most, which you made the most amount of money, and then we'll calculate your benefits based on that. So even if you've been out on leave for a while and you don't have any earnings, what we're going to do is look back a little bit more than a year and see what your earnings have been over that period. And that's what we're going to use to calculate your benefits. And it's for exactly that reason, where you might have had some unpaid leave in there that would disrupt that calculation. So we want to look at what you would make in an average week and calculate it based on that.
Gotcha. Okay, my next question, I'm going to kind of combo because we're getting quite a few of these. And this, staying with you, David, a lot of folks want to know how family works with either short-term disability or FMLA, where they can go for kind of resources about kind of coordinating all those benefits and leave together.
All right. So as for where you can go, take a look at our webpage. We have a lot of guides out there that will answer that. Let me give you the really easy answer though. Nothing that happens outside of our system here for family impacts your eligibility for family leave. Again, you'll come in, you'll file an application for benefits. We'll determine what benefits you're eligible for. And we don't take into account if you're receiving short-term disability or if your employer's providing any type of paid leave or if you're taking PTO. We calculate the benefits you're entitled to under the law with the calculation process that's set forth in statute, and that's what we're going to pay you. Now, your employer may be able to modify some of their programs. So they might reduce your short-term disability. If you are using PTO, they might limit that to what we would call a make whole provision that would bring you back up to 100% of your pay, but to make sure that you're not earning more while you're on leave than you would while you were working. So all of those other programs can be modified by the employer, but that's really up to the employer for how they want to do it. None of that's going to reduce the benefits that you're entitled to from us.
Interesting. Okay. This is kind of a twist on that. So can you apply for FMLA and then apply for family, or do you do them both at the same time?
They're going to run concurrently. So
Okay.
if you're using FMLA now, obviously they can't because there's no family. But when we get into the flow of things starting in 2024, family and FMLA will run concurrently. So you will have that federal job protection as well as the state job protection. And then you'll receive your actual benefit payments under the state system.
All right. Okay. Kind of, this is a good one for Tracy, I think. Tracy, Cynthia wants to know, how do physicians register? Is there a link where that I can give my employees to help find their physicians?
Absolutely. I'll have the team drop that link into the chat for you, but the process is very, very easy. It takes probably under 10 minutes, if that, for our providers to get registered. And then when they are wanting to do leave recommendations moving forward, it will just be a minute or two's process rather than handwriting forms out like they currently do. So all that information is available, and we will pop that link into the chat for you. But please do encourage providers to register, because it will make this process a lot faster for them and for all of their patients.
Great, thanks. All right, and another one, this was probably back to David. Dominique wants to know, David, if my employer is located out of state, but I'm seeing family deductions on my paycheck, but my employer's out of state, how does that work? Can I still get it?
Yeah, absolutely. So we have a whole process on what we call localization. There's some great resources on our website that really help employers figure that out. But if you're working in Colorado remotely for an out-of-state company, you're still considered a Colorado worker. Your company is doing the right thing, taking those deductions, and you are absolutely eligible for leave. And our rules and our laws are binding on the company for that. So you will still be eligible to apply for and receive these benefits.
Great, thanks. Next question, I'll stay with you, David. Casey wants to know, will the state notify my employer when I file for family? What's that going to look like?
So we are working on building out that process in our portal. The answer is yes. We're going to let your employer know because we kind of have to let them know that you're eligible for leave and that they can't fire you for not showing up the next day because we've approved your leave. That's going to be handled through our online portal. We really are encouraging all employers to provide a HR representative designation. So give us a name and an email for who that will go to. When employers signed up in our system, they did provide us with contact information. A lot of times that might be somebody in payroll, and for larger companies, that's going to be somebody completely different from HR. That's the person who we're going to contact, whoever the employer tells us to contact, to let them know that there's been an application for benefits and when that application is approved.
Cool. All right, next question, still with you, David, is from Jessica. Jessica wants to know, let's say I get my family benefits for bonding leave, but I work part-time to supplement my pay. Can I still get the full family benefit, or will it be prorated based on the hours I'm working?
Yeah, so it's going to depend on the employer that you're taking leave from. So if you work for two employers, So you've got one job and then you've got a part-time job that supplements your income, but you're only taking leave from one employer, then yeah, we're going to adjust your benefits and the amount of leave that you're taking. We would really count that almost as like a reduced schedule leave. So
Mhm.
you would get benefits based on that. If you're taking leave from both employers, then we're going to look at the wages that you've received from both those employers and calculate out your benefits. So a way to think about this here is that your benefits are going to be based on the wages that you're losing by not working. So yeah, your benefits would be lower if you are still working and earning, because we're not going to include those other wages. So it really depends on how you're structuring your leave.
Interesting. Okay. I'm going to combo two questions here because it's kind of the same. Still with you, David. Amy and Sam want to know. Oh, sorry. Sorry. Amy and I think and Trayton want to know what's the anticipated turnaround time from the time I apply till the time I get my benefit. I know it's not, this program isn't up yet, but what can you tell folks about how long they should expect once they get their applications in to start getting paid?
So under the law, we have 14 days. I personally would be extraordinarily disappointed if it was taking us 14 days. And our goal is to be very quick with these. So some cases are going to be kind of auto adjudicated, and those are going to go very, very quick, that we're going to be able to verify that all of the documentation is there. Some cases may require a little bit more of a review. That's probably going to be true of a lot of the these bonding leave cases where there's going to be some documentation coming from different sources. But we're still going to be hoping that this is substantially less than the 14 days that we're allowed under the law. We
That
don't
makes
want people
sense.
sitting around there waiting and wondering.
All right. Next question here is from C Rivers. Not sure your first name, C there. Question for David. What if I work 50-50 in Colorado? Can I still get family?
All right. So every time I try to answer a localization question, I tend to get it wrong. That's why I always tell people go look at the website. But we do have some other experts here, and I'm going to ask Evan. Can you weigh in on? I don't believe we're going to prorate, right? That we would just be looking at if you qualify as a Colorado employee. But Evan, do you think you could take this one?
Sure. It is important to note that we don't prorate. In determining localization, we're determining whether or not all of your wages from a particular employer are covered. And so if it really was purely 50-50, which may in fact be rare, and we would have to look at the first question would be whether or not, work somewhere else is incidental to the work somewhere else. So we do have on our website sort of a flow chart that helps people look at, based on their circumstances, whether or not they would be considered localized to Colorado. But at that point in the analysis, without diving into the weeds too much more, we would just have to look at, is the work outside of Colorado, incidental to the work inside of Colorado, or vice versa. If the work outside of Colorado is incidental to the work inside Colorado, then you're still covered for all the wages. If it's the opposite and the work inside Colorado is really just incidental to the work that you perform outside of Colorado, then none of those wages would be covered. But again, there's a lot of nuance here. So this would be something to provide a valuable answer. We'd have to know a lot more information.
Interesting. All right. But you can always call our call center if you have very specifics and you want someone on the phone to walk you through it. Another question here for policy team. Who wants to take this from Melissa? This is a twist on the baby born in 2023. Melissa wants to know, my baby was born in 2023. So I'm eligible for leave in 2024, but if I choose not to take it, can I get paid out for the time? Can I get the cash payout?
No, we're not going to be doing there's no retroactive benefits. So if you took unpaid leave in 2023, you can't come in and get benefits while you're still working in 2024, but you would be eligible for that additional leave in 2024. So
I see.
you can take the leave and get the benefits with it, but you can't we're not going to reimburse for unpaid leave taken before benefits were available.
All right. Another question here, David, is from Carolyn, and this kind of goes back to the coordinating of benefits. A lot of folks are asking, so, okay, just walk us through one more time. Can you just choose whether to take FMLA or family? When you apply for one, does it automatically account for the other? She wants to know, can an employee refuse to take or apply for family leave and choose only to take FMLA and their employer benefits? Or do you have to get family when you apply for FMLA?
The application for family is up to the employee. Employer can't require an employee to come in and take this leave. So now the employer can provide FMLA documentation and request that it be filled out, and that starts a ticking clock there with the FMLA. I can't really answer questions about how the federal program works there, but the employer can't make you do this. So if you're out there taking some leave, you're taking unpaid leave, and then you come back and file for family, we look at family just under those circumstances, which is, are you eligible for this benefit at this time? And we don't consider anything that may have occurred prior to that. So it would theoretically be possible for somebody to do that.
Gotcha. All right. One more kind of medical question here for Tracy to combo. I know we went over this, but if you could just repeat to folks a little more detail again, Tracy, for the kinds of childbirth complications that would be eligible for medical recovery leave. Sandy asked, things like a C-section, or what kinds of things does it require hospitalization for the complication? You just talk a little more about that. How we'll determine the extra eligibility.
Yeah, absolutely. So a C-section is not considered to be a serious health complication. Typically in short-term disability programs and other disability programs, you would find that a vaginal delivery would have 6 weeks of time away from work, and typically a C-section would have 8 weeks of time away from work. That is certainly very well covered by FAMLI, which will offer the 12 weeks. Those serious health conditions that are related to the pregnancy and childbirth, you're going to be thinking of things like maybe HELP syndrome, the moms that are on mandatory bed rest for a significant amount of time due to preterm labor risks. Maybe they need that additional 4 weeks before they actually deliver the baby. And then they could take the 12 weeks once baby is delivered. Those kinds of things may be considered a serious health condition. But the more kind of direct response to that is any of the extensions for a serious health condition will have to be approved by a healthcare provider. So absolutely, you would need medical support for that additional time.
Interesting. Thanks. All right. Back to David. A question from Sydney here. What happens? Can I take family if an employee leaves their job? Are they eligible for the 12 weeks as long as they paid into the fund for the prior year? Some people obviously leaving for babies don't plan to return. So what happens there?
Family leave is leave from employment. So you do need to be employed when you take that leave. If you've left employment, you're no longer employed, so there's not leave eligible there. Now, there is a little bit of wiggle room here, which is if you are on continuous leave and your employment terminates while you're on leave, but we've approved it, your leave would continue until the end of that approval. But generally, you do need to be employed in order to take leave.
All right. Follow up here from Marina wants to know, can I request family leave, but then postpone it or cancel it?
Yeah, you can. That's going to be a function available, I believe, through our portal, but if not, our customer service unit would be able to help you out over the phone with that. And that will happen. Somebody might put in for leave because they've got a scheduled surgery. Circumstances change. They end up not having the surgery. They may wish to withdraw that application, cancel the leave, or postpone it. I'm not 100% sure on our tech side if you can postpone it. What we might end up doing is cancel and refile. But yeah, if you've got an advance approval for some leave because it was anticipated, you do have that ability to modify it. And I just want to add on to this. There can well be circumstances where you're going to have to do that. So let's say you get approved for a certain amount of leave, but you decide during that leave, you had a serious health condition, it resolves, or you decide you're okay to go back to work, and you go back to work before the end of that leave, you need to let us know and cancel that remaining leave. If you are you're working and you're receiving benefits, we might call that an overpayment. We might call it fraud. So you definitely do want to come let us know if that leave should be canceled for that remaining period.
Interesting. All right. A question here, still for David from Lorraine. Lorraine says, a scenario, I work for a small company that has no HR department. If I submit my claim on the My Family Plus portal, oh, it just went away. On the My Family Plus portal, will my checks come from the state or from my employer?
They will come from us. So we manage the family fund. That's what all of the premiums go into. And from that fund, we will be paying benefits. So the employer gets notified that leave is occurring. But all of the administration is done here through the state family division. We will process it and we will pay you your benefits.
All right.
I would just add in there though, Kristen, it will not be a check, right? We're not sending out physical checks. It will either be in the form of a direct deposit, which is what we're going to be highly recommending for efficiency in receiving those payments, or we will send a debit card, but we will not be sending checks.
Gotcha. All right. This kind of, I think, is a question for David. David Matthew wants to know, does he get job protection immediately upon applying for family? In other words, if my baby is due March and it just went away. Sorry. I'm sorry, guys. My screen is just fritzing on me. Let me go back up. I got halfway through that question. I'm going to scroll back up. Appreciate your patience. Zoot, slow. I promise I'm good. Okay, sorry. It has completely vanished from my screen. I am so sorry.
Right. Well, based on what you said, I think I can answer.
Okay,
So
sorry.
Let's start with job protection kicks in once you've been at a job for 180 days. So that is just a question of eligibility. If you're a new employee, you don't have that. Once you've been working there for 6 months or so, then you're covered and you have that. But then, yeah, to get to the question that I think you were asking, your job protection does kick in immediately. So we have what we call as retaliation interference rules, and they're actually written pretty broadly in the law. So you can actually have some protection here if you haven't even applied for benefits yet, but you just tell your employer, hey, I'm going to be applying for benefits, and they take some sort of an action that could be considered retaliation or interference. So yeah, the employer really can't do anything to stop you from taking these benefits. So you would have that protection there from the moment that you apply. It could even come in a little bit earlier if you just give some advance notice to your employer. They're not allowed to take any type of retaliatory or action or to interfere with your application.
Great. Thanks. All right. Another question here for David from Brittany. Brittany wants to know, what about health insurance that we pay out of our paycheck? Will we have to keep paying our employer out of pocket to continue our health insurance while we're out on family leave?
That's a great question. Your health insurance will continue, but you do still have to pay for whatever portion you were paying for before you took the leave. Employers can work with you on a lot of different ways to do that because normally they're going to be deducting that from your paycheck, right? But if they're not writing a paycheck, they may ask for you to pay that portion to them. Some employers will continue it, and then when you come back to work, it'll be an additional deduction. That's something you definitely want to talk to your employer about. So yeah, you do have to pay for it, but the actual way that you're going to pay for it is an issue between you and your employer.
Interesting. All right. Next question. Molly has a kind of a follow-up question about babies born in 2023. Molly wants to know, someone told me this only applies to people who have babies in 2024. So my due date is until 2024. But if it comes a couple weeks early, does that affect receiving the family leave at all?
No. So you're eligible for leave within that first year after the birth for the bonding leave. You wouldn't be eligible for anything in 2023, but really for any babies born after, I think, April 1st in 2023, as long as there's 12 weeks between January 1st and the first birthday, the parents can get 12 weeks of leave in 2024. If there's less than 12 weeks, they can take up to that first birthday. So
Gotcha.
yeah, you can take it anytime during that first year after birth.
Interesting. All right. Sorry about this. All right. It's a question still for David from Dominique. Dominique wants to know, can my employer terminate my employment if I take unpaid leave in 2023 and then paid in 2024?
So that falls under that retaliation and interference, that if you're planning on taking family leave, or if you do take family leave, your job is protected, assuming that you've been there for 180 days. So yeah, your leave, your job is protected when you take that family leave. They can't do anything to stop you from taking that family leave, and you would be eligible for that protection.
All right, follow up, kind of similar from Chelsea. Another thing about can my employer do? Can my employer deny a request to split my parental bonding leave into 2 segments? Can they require me to take all 12 weeks at once?
Nope, it's your leave. And so we will award that leave on that basis, based on your request. The employer cannot, again, prevent you from taking leave or require you to take your leave in a certain way.
Gotcha. All right. One more for David. You're getting all the hard ones. We always get this question, so you knew it was coming. The tax question. Trayton wants to know, what are these benefits? I hear they're not subject to state tax. Are they subject to federal tax? What do I do?
All right. So absolutely right. Benefits are not subject to state tax. Colorado is the 13th state, I believe, to implement a paid family medical leave program. We were the 13th state to ask the IRS to clarify whether or not such benefits would be subject to tax. And we were the 13th state to be waiting for an answer. So I can't answer that for you. What I can tell you is that we are going to issue a 1099-G. So that's a form that will show that you did receive these benefits on a IRS tax form. But then I would advise you to talk to a tax professional, or even try contacting the IRS. They have not told me whether or not these benefits will be taxed or not.
So what Trayton wants to know is, can I go ahead and withhold federal taxes at the time of payment, like unemployment?
No, we won't be calculating withholding for you. So we will pay you the benefits you're entitled to under the calculation for state law. And however you want to approach that taxation will be up to you. And again, consult with a tax professional.
All right. This is interesting stuff. Thanks so much. All right. Some folks want to know a little bit more about how to know if their employers opted out. How does that change things? And talk a little bit about opted out employers, David.
All right. So as far as actually opting out, the only employers who are allowed to do that are local governments. So if you work for a town, city, municipality, special district, they might have opted out. They should have given you notice. And definitely check with your HR to see if that has happened. There are some other categories, and we don't talk about these as employers who have opted out, but employers can either hire a private insurance company to provide the same or better benefits than the state system does, or they can self-insure, again, as long as they provide the same or better benefits than the state system does. Both of those cases, employers are required to notify employees and should have told you if that was the path they're taking. Now, they might decide somewhere in the future to do that, but again, they should give you ample notice that that's going to happen. So what you'd want to do then again is also check in with HR to see if there is something out there. We will do some of that. If you come in and apply for benefits here with the state system and we don't see that your employer is in our system, we would look at that and then we would let you know, hey, there's a private insurance company that's handling your benefits out there. But again, your employer should have told you that. So if they haven't, if you work for anything other than a local government and they haven't told you, that they are going to be having a private insurance company or they're going to be self-insured, you should assume that any leave requests would be filed here with the state and that you're going to be handled under the state system.
Interesting. All right. Another question here for David from Molly. Molly wants to know if I'm taking the intermittent leave. Remember, we talked about the different kinds, continuous, intermittent, that kind of. She says, if I'm taking my leave intermittently, do you have to know the exact dates when you apply for leave?
Not when you apply for leave. You'll come back into the portal, I believe, on a weekly basis and let us know what leave you're taking, so we can calculate out your benefits and reduce your leave balance accordingly. But this is the kind of thing where generally we assume if you're taking intermittent leave, you may not know at the time you apply for it. It's that kind of thing where I mentioned, if you got a flare up of some sort of common illness or chronic illness, you may not know that you're going to need that leave.
Interesting. All right. Just to let everyone know, we're at 5 minutes here. We're trying to get to as many as we can, but if your question is not answered, you can always call us, email us the contact information. And just so everyone knows, you're going to get this full deck, the recording and all the Q&As in your email box after this seminar. And we will have lots more opportunities for you to get these questions answered, but we love all the questions. Just want to let everybody know, we probably won't get to all of them right now. Next one, as we wind down here, David, this comes from, comes from Allison. This is about job protection. Allison says, I have not been with my employer for 180 days, so I don't have job protection. If I apply for FAMLI, can I be terminated from my job, but can I still get family benefits?
All right, so let's break that down a little bit.
Don't have job protection, but can you still get money?
Yeah, so if you apply for benefits and you get approved, that puts you back to what I said a few minutes ago. You're on continuous leave, your benefits will continue for that. You don't have job protection in that circumstance under the FAMLI program. But there are other federal programs out there. I'm not an expert in them. Some of them are brand new. There are other state protections out there. So it's not necessarily that you may not have job protection. It's just that you don't have job protection from this program. But you would definitely want to look at some of those other available protections to see if they might apply. But to answer your question, yes, if we've approved your leave and then you're terminated, you would be able to receive that leave as we approved it.
All right. Next one, still with David. This is from Shana. I hope I'm saying it right. Shana wants to know, she says, I'm only part-time. If I'm part-time and I have a baby, does that mean I only get 6 weeks of FAMLI instead of 12?
So we use a subjective calculation. So what we do is we look at your work schedule. So if you're part-time, really here, it doesn't matter. If you take a full week off, there's 7 days and you have not worked in any of them, that counts as a week. So you would still get 12 weeks, but it's based on your work schedule. So if you work less than 40 hours, you work more than 40 hours, we look at how many hours you work, and then we'll calculate your leave based on that. So again, if you're taking continuous leave and you don't go to work for 12 weeks, it's going to be 12 calendar weeks, regardless of how many hours you work in an average week.
All right. I think we might be really nearing the end here. But one more. Sorry, my screen is kind of jumping around. Daniel wants to know, this is a good one kind of for everybody, kind of as we wind down here. What can folks be doing to get ready for the application process? We can apply 30 days before you get the leave, but what kinds of documentations do we need to get ready for our healthcare providers?
So, Tracy, would you like to answer that?
I was just going to say, you know what, we will be opening up our system here in the coming days and weeks. So sign up for our newsletter. You will then be notified directly as soon as our portal is open. And as far as planning ahead and getting ready for your leave, we're going to give you plenty of time. You'll have more than that 30 days that you need to notify your employer. I know that today we've answered over, 180 questions, We still have about 90 sitting in the chat, along with all the ones that we've answered live. But I would say the best thing you can do right now is to sign up for our newsletters, receive the alerts immediately as soon as we've opened our system up for public use, which will be well within the 30 days that you need to notify your employer.
All right. Well, I see that we're at time. I want to thank everybody again for attending. If we didn't get to your question, check with us at all these venues you see there, and we will be back again. We do these pretty frequently, so sign up for those newsletters and check our websites and get all the updates, and email or call us anytime. We were so excited that you joined us today.
Thank you so much. Bye-bye.
Thanks.